All right. So, Hannah, would you like to go first?
Sure, I can do that.
All right. Is that good? We want to.
Yeah, I think that probably makes sense. And I think Jonathan might go into a little more depth than I will, but yeah, I'm happy to give an overview. So I'll go ahead and share my screen if that's okay.
Yes, absolutely. Absolutely.
Okay.
Do you want to do a better introduction than I did of who you are?
Oh, I think that was pretty good.
Okay.
So I'm a staff attorney with Westside's Preventing and Ending Homelessness Project. We provide free legal services to tenants in LA County, and we provide services regardless of immigration status. Our work includes giving counsel and advice about housing issues, all the way to representing tenants in eviction cases. So we see, kind of the whole scope of housing issues that tenants are facing. And so I am really excited to talk to you all today. I know it's a confusing time because for the last 3 years, we've had a combination of state protections, county protections, and city protections for tenants that have been impacted by COVID. And at times the laws were very confusing because they overlapped, they contradicted each other. And but nevertheless, they did provide some protection for tenants at a time when, a lot of people were unable to pay their rent. And now we are finally at this stage where these protections are being phased out. So it's good to just check in about what's happening, what the implications are, and what permanent protections still exist for tenants unrelated to COVID. As we've discussed, the COVID protections are ending. LA County has had protections in place. They are still in place through March 31st. And so we will spend a little bit of time on those protections in a moment, but I think for the purposes of this presentation, it's not really as important to talk about those details. What I really want to explain is just that the protections expire on March 31st. And so going forward, tenants will not have a way to defer their rent payments. Also, there were various resources, over the last few years for tenants that needed assistance paying their rent. So that included the state Housing is Key program that provided rental assistance for many tenants. And so generally speaking, there is not rental assistance available for people that can't pay due to COVID. So starting April 1st, tenants will need to pay their full rent, or they have faced the risk of eviction. If a tenant does not pay their rent, they may get a 3-day notice to pay rent or quit, which is also known as an eviction notice, a termination notice. And so what that means is if that notice period expires, if the tenant still hasn't paid their rent, the landlord may file an eviction case in court. And so since we have a little bit of extra time today, I'm going to speak briefly about these county protections. But again, it's just to give you a little background, I wouldn't worry so much about the details because these protections do expire at the end of this month. So the county has had protections in place for tenants that will rent from July 2022 to March 2023. So we'll talk about those in a moment. There also have been protections in place for tenants that have unauthorized occupants in their unit, or pets, or perhaps nuisance related to COVID. So an example would be if, let's say you had a relative that had to move in with you because of COVID, or maybe that relative had a pet and needed to move in with you, the landlord wouldn't be able to evict on the basis of that occupant or that pet. There also have been protections against no-fault evictions. This was a really important one because normally landlords, there are certain grounds for eviction that landlords can do even if the tenant did not do anything wrong. It could be that the landlord, for instance, wants to move in, or they are trying to withdraw the unit from the rental market. And for the last few years, there have been protections in place against no-fault evictions. The county protections did have some allowance for certain types of owner move-in evictions. But again, these protections are coming to an end at the end of this month, so we may see an increase in those sorts of evictions. And then this is just a review of the county protections for tenants that can't pay. So there actually have been a few requirements for tenants. It's not automatic. There were a few things that tenants needed to do to qualify. So tenants that made a low enough income that could not pay due to COVID-19 financial impact, and who gave notice to their landlord within 7 days of the rent coming due, those tenants will get protection under the county emergency tenant protections. And what that meant is rent was not canceled. They still owed their rent, but it was deferred. So there is a 12-month repayment period. So starting that 12 months starts on April 1st, and it runs until March 31st, 2024. And so that is for tenants that could not pay their rent and did the proper landlord notification. And we'll talk about that. So the first requirement was that these tenants needed to make low enough income. And so this chart explains what that income is. It's just based on the HUD area median income. So for example, a household of 2 where the monthly income was, let's say $4,000 would fit under this requirements because it's less than 6,354.16. Okay, and tenants also needed to be unable to pay due to a COVID-19 financial impact. So basically, that required either a reduction of at least 10% of their income compared with before COVID, or an increase in expenses of at least 7.5% more than before the pandemic. So that is how the county was measuring the financial impact. You have to fit within those guidelines. And then finally, so it wasn't enough for a tenant just to say, I qualify, I fit within these guidelines. They actually have to tell their landlord. So this notice is on the right. This is from the county's Department of Consumer and Business Affairs, this sample notice. And so this is something that tenants can provide to their landlord. They'd have to provide it within 7 days of the rent coming due. So at this point, we're at March 16th, it is more than 7 days after most people's March rent is coming due, but the law does allow, it's possible that providing it late rather than not at all could help a tenant. So, they can still provide this when it comes to months between July 2022 and March 2023. But again, going forward for April, this isn't going to do anything. But anyway, this notice just explains that the tenant falls within those income guidelines we talked about and was impacted by COVID. And so then this slide just kind of reviews what we've said. So for that period of July 2022 to March 2023, tenants that made a low enough income, which we talked about, falling within the income on that chart, and tenants that could not pay rent due to COVID financial impact. So that's the 10% loss of income or 7.5% increase in expenses, and gave that notice within 7 days of the rent coming due, those tenants would be protected under the county law. And those tenants, for those months listed, they would have until March 31st of next year to repay their rent. Now, again, this is expiring at the end of March. And for a tenant that doesn't pay, let's say their April rent, their May rent, those tenants do risk getting an eviction notice and eventually getting in the eviction process for not paying those months. So there still are some protections, though, for tenants that are facing eviction. We have certain permanent protections, and these include just cause protection, which means that landlords need to have a good reason to evict tenants. Now, there are different, whether or not just cause protections apply will depend on where a tenant lives. So for example, in Los Angeles, in the city of Los Angeles, there is the rent stabilization ordinance, which is a law that actually controls how much the landlord can raise the rent once a tenant is living there, and the grounds that a landlord can use to evict a tenant. And there's even a new law that applies for tenants that are not covered by that rent control law. There's a new just cause law that limits the reasons that landlords can evict. And these sorts of just cause protections have been in place in many jurisdictions before the pandemic. Some of them are newer. The Culver City ordinance, for example, is newer. And these are permanent protections. That means they're going to continue to be in place even after, after COVID. And in some cases, landlords have to follow certain procedures in order to evict the tenant. Landlords don't always know about these procedures. So this is a really good thing for tenants, and it's important for tenants to talk to a lawyer and find out what protections apply to them, because again, it's very specific to where the tenant lives. Is it a single family home, or how long have they been living there? For each city, the laws are slightly different, so I won't get into too much depth about what each law covers, but just know that these protections are out there and they can really help tenants. There is also the statewide Tenant Protection Act. That law, because it went into effect not that long before COVID, people don't always think about it as often, but that law provides certain protections depending on what kind of unit you live in. There are exceptions to this law, but for tenants that are covered by the statewide Tenant Protection Act, there are limitations on rent increases, and there are limitations on the reasons landlords can evict. And it's just important to know in general that for places that are covered by one of these laws, landlords can't just evict for no reason. Often we hear tenants, they get a notice from their landlord and it just says, okay, you have 30 days to move, and there's no reason. And in general, for people that are covered by a just cause law, that's not a reason to evict. You have to give some reason. And another thing that happens often is that tenants will say, oh, my landlord's selling the building, so I have to leave. And that's not a permissible reason. There are certain reasons that related to selling the building, perhaps if the building is being taken off of the rental market entirely, but there's a whole separate process for that. If the building is just changing hands, that in its own, that's not a reason to evict. So it's important just for tenants to find out what their rights are if they if their landlord is giving them a formal written notice, or even if the landlord is just verbally saying stuff. It's important for them to get in touch with a lawyer. Often tenants, after they speak with us, they'll say, oh, I didn't know I could stay. My landlord really made me feel like I needed to leave, because there's a power imbalance. People don't know what their rights are. Okay. And just want to talk a little bit about what's coming next. So unfortunately, we've been seeing a lot of cases lately where tenants owe a lot of back rent. And I think as protections expire at the end of this month, we are going to see a lot of non-payment cases. And we're going to see a lot of these cases where tenants owe rent for many months. Some tenants, unfortunately, they think that their rent has been waived, but that's not the case. Or sometimes tenants think there's still, a moratorium on evictions and they can't get evicted. And unfortunately, that's not true. So we want to make sure tenants know they still do need to pay their rent, and they do need to respond to eviction cases. These protections that we talked about, the just cause protections, they are really powerful, but they don't just automatically apply in most cases. Like if your landlord is suing you for eviction, if they go to court, the tenant is the one that needs to respond and say, actually, you violated this law. And if the tenant does not respond to an eviction case, they will lose their case. So it's very important that tenants know that they should get legal help really at any stage of the process. If they get an eviction notice, they should get help. But if they get served with court papers, it's important to know they will have only 5 days to respond if they get a summons and complaint for eviction. So it's important to refer tenants right away to get legal help. And so this slide would say, how's the lay? This is a website tenants can put in some of their information, just contact information and a little bit about like what situation they're in. Did they get court papers for an eviction case yet? And their pictures to kind of help tenants figure out like which document they may have gotten. And then it goes into this referral system. It will refer tenants to a community-based organization and a legal services provider, including Westside or LAFLA, and that'll just depend on which geographic area they're in. So tenants can go to this website. They also can call this phone number if the website is not working for if they don't have access. And you can access the website on your phone or a computer tablet. And then finally, this is the contact information for Westside. We have our main number listed 323-939-0506. That's the main intake number. We also have certain contracts with Culver City, West Hollywood, and Beverly Hills to provide legal services for tenants. And so for those cities, there are dedicated phone numbers and dedicated email addresses. So if you're working with a tenant, let's say in Culver City, it's best to direct them to that phone number and to that email address. It will come to us much quicker. So I'd like to open it up now for any questions.
If you have questions, if you want to put the question in the chat, if that's better for you, or you can just speak up. Either one. Well, I have a question for you.
Oh, go ahead.
one of the things that we have realized is that, there are some people out there that just took advantage of, oh, I don't have to pay rent. And now you've got, I mean, even if you were living in a very modestly, priced apartment, say $1,500 a month times, 12 months times 3 years is $54,000 that now they owe. And, whether or not they get evicted from that, they still owe that money, correct?
Good question.
Whether or not they get evicted. So there was a time period, separate from that. Yes, they will owe the money. However, sometimes in these eviction cases, what we try to do, if the tenant is feeling that they don't have the money to stay, and it's just not really a sustainable place for them to live, and they're willing to do a move out agreement, we will often try to settle these cases with some rent waiver, so that they can just kind of move on from all of that debt.
So Hannah, would that mean that they need to have representation to get that?
To get the waiver? Well, not necessarily, but I think it certainly helps. I guess I would say in general, if you're in an eviction case, it is a very, very good idea to get representation. And thank you, Jonathan, for putting the information for Westside and LAFLA in the chat. I'll also put all of these phone numbers and email addresses in the chat in a moment. But it's always a good idea to get legal assistance, because this is the laws are very complicated, and I think somebody representing themselves is definitely at a disadvantage. And when it comes to negotiating a settlement agreement, yes, a tenant who's representing themselves might not be aware of all of the the typical terms that go into a settlement agreement, or how to negotiate something that's more favorable. So I do think it's a good idea for them to have representation, even if all they want to do is just move out and be done with the case. For instance, when we settle cases, we always try to get a settlement that says that the record is going to stay sealed. That's very important for our clients. If they have an eviction judgment on their record, that can be really difficult, make it really difficult for them to find a new place to live. So it's like those sorts of things that in working with an attorney and getting free legal services, that can really help you get a better deal.
Okay, and oh, go ahead.
Oh, sorry. Yeah, I didn't see the raise hand button, so forgive me if I'm interrupting. Just with Sofisa, we serve homeless and low-income families, helping them get into housing, but we also serve local community members, landlords. And so is there, I think Rosalind asked this in the chat, are there also protections or resources for landlords who didn't receive the rent? Do you work with them as well, or just specifically on the tenant side?
Yeah, so we work on the tenant side, and unfortunately, I'm not really sure what resources would be available to landlords. I'm sure there are, but I'm not the expert on what those are. And I think Elisa has a question.
Yeah, so with a STEP fund, we're making zero interest microloans from a philanthropic fund for people at imminent risk of homelessness. And just for people that don't know us, we are also able to lend for people who are coming out of incarceration or domestic violence, where they haven't received an eviction notice, but they need move-in money. So one of the things that we're encountering, Hannah, is people who are coming to us that owe 12 or 14 months of back rent, and they've been referred to us. Our average loan is about $2,000. Mm-hmm. So there are loans for low-income people to help them prevent being evicted from, imminent eviction, but we're not able to give them the money. And so a loan from us wouldn't kind of help them. So what do you see in practice, or maybe it's still a little bit theoretical, for these tenants who owe so much back rent that they will not be able to pay? Are there settlement sort of structures that you and your team are working toward, or what is the advice that a service provider can be giving these families?
Yeah, well, I guess it seems like those sorts of agreements, it would probably be pretty case by case, like what would make sense. Does it make sense for them to find a new place and, and move and use that money? Or maybe it doesn't. Maybe they've been living there a really long time and the rent is so low that it's, they're not going to be able to, to find anything, and really they would have to leave their community to stay within that, same amount of rent. So I think it really would depend on the situation. I guess maybe some combination of like other rental assistance funds, like maybe through that could help them with the back rent perhaps, and then they could use this loan for some of the rent going forward. I did, let's see, I have worked a little bit with several organizations that provide rental assistance for people living with HIV and AIDS. And that's, of course, like a very specific situation, but I've found that a lot of the community organizations, they do really good work, and they
oh wait, you can't see the screen, sorry.
Okay, please mute yourself.
So yeah, I mean, maybe just exploring some other resources to try to cover the back rent. And that was just an example of one of those. And, I think there could be a situation where, like, yeah, they haven't paid their rent, but maybe the conditions were really bad. And during the time that they didn't pay rent, and perhaps the landlord might be willing to like waive some of the rent. That could be an option. But I think it would probably depend on, exactly what situation the tenant was in and whether they want to stay or go.
I think that that kind of ties into Ebony's question about will there be additional help to pay rent after the moratorium ends? Do you know of the supervisor's funding or, whatever, county, state, local, city?
Yeah, I honestly, I don't know the answer to that. I mean, there was, a lot of federal and state money that went into the Housing is Key program. And I think that there's like definitely recognition that, people are in a tough spot. And, in terms of like some recent changes to the Just Cause ordinance in LA, and in the city of LA and the county of LA, there's been a movement towards landlords need to, they can only evict for non-payment when it meets a certain monetary threshold, like when the tenant owes a certain amount already. So I think there is an understanding of like, okay, we know that tenants can't necessarily afford their rent, or that, they might owe some rent. We want to like limit displacement, but I don't know the answer to that question about like what future funds are planned. It is very good to know about that program, by the way, with the zero interest loans, that I've made note of it. So thank you.
Also, Yvonne Biggs from Venice Family Clinic put landlord protection information and a link to that. That's really an important link because there are a lot of mom and pop organizations. And then Genevieve had a question, how long do tenants have to pay back the rent? Can they pay it off over time?
Yeah, so with respect to the county tenant protections that we talked about, the repayment period ends on March 31st of 2024. So it'll be 12 months starting from April.
Okay, well, I know we're going to have more questions for you, so you and Jonathan can both answer questions at the end. I saw that Zach had his hand up. Zach, do you have a SD3 question? since you're
Hi.
connected to those things?
Hi, Zachary Geidzik with LA County Supervisor Lindsay Horvath's office. I was just going to say, when it comes to rental repayment programs, we're working on developing one. We've allocated 45 million so far, and it's not fully fleshed out, but I will just say it's something that we're very aware of and something that we're working on to try to figure out how we can do that. So just want to let everyone know we're working on it.
Awesome. That's important. Thank you so much. Because you're right, the mom and pop landlords are, also really at risk here. So it's important. Jonathan, I want to introduce you. Can everybody please mute yourself? Okay, Jonathan, I want to introduce Jonathan Irwin, and he is the Deputy City Attorney for the City of Santa Monica. So Jonathan, it's all you.
Hi. So yes, I'm the deputy city attorney, and just to clarify, since I know I think I got an accidental promotion at some point.
Yes, that was on me. I put you as the city attorney.
So I'm basically a staff attorney in the city attorney's office, but I do work, very frequently on landlord-tenant issues, and so I deal with some of these things very often. And so I'm going to focus on Santa Monica and go into just a little bit more detail about the permanent protections that are in place. As most folks probably know, the Santa Monica moratorium, or what we've been calling the moratorium, ended at the end of February. And so there is still that county moratorium that Hannah was telling us all about that's in effect through the end of the month, but there aren't special Santa Monica specific protections in place. So I'm going to go ahead and share my screen. I also have a short PowerPoint here. All right. There we go. All right. So some of this will be, going over kind of how this looks in Santa Monica for some of the protections that Hannah already mentioned, but I'm going to go over rent control and just cause for eviction. There is something that is special to Santa Monica and I think several other jurisdictions throughout the state. It's relatively narrow, but just something to be aware of if there is a teacher or a student or a person who otherwise works in a school and it's during the school year. And I'll talk more about that in a moment. Anti-harassment protections, tenant harassment, and then I'll talk more about what that is. Tenant relocation, and then I want to cover resources in Santa Monica. So I'm going to go very quickly through this since I think Hannah already mentioned it, but just reiterate, if a landlord is threatening eviction, if there is a notice, and certainly if you get a summons and complaint, kind of the initial papers that start an eviction case, it's extremely important to get attorney as soon as possible. And we always have to clarify for tenants that, we can only represent the city. We can't represent any individuals. So we can't be someone's attorney in an eviction case.
And I wanted to take a cup of coffee.
Oh, I think someone might have their audio on. What? If YMA Santa Monica could mute themselves, I think that might.
I know who that is. I'll text them.
Okay.
You should silence them, Darcy.
You made it worse.
Yeah, Darcy, you might be able to mute
I
them.
can just ask ask them.
Okay.
All right. So I'll try to power through here. So we do take questions when people are sort of wondering what tenant protections or eviction protections apply to them, but we can't represent tenants. And certainly if someone believes they're experiencing or one of their clients is experiencing tenant harassment, they can also reach out to the city about that. So what does rent control and just cause look like in Santa Monica in particular? Many of the lower income clients and people who might be facing eviction are in fact in rent controlled properties, but it's not every apartment in the city. Generally speaking, rent control, which limits rent increases to generally 3%, applies to apartments built before 1979. But just like in LA, as Hannah was describing, the just cause ordinance, where you have to prove a specific reason to evict someone, that is broader and generally applies to almost all units that are not single family homes or condos. And so with Santa Monica, sorry.
Darcy, please silence them.
Jonathan, you might be a co-host too, so you could potentially mute them.
Oh, I think I can.
Yeah.
Oh, hooray. Okay. I have not been on Zoom in a long time, and it was that easy. Thank you for pointing that out, whoever that was. All right. So you can only evict for a very limited number of reasons. So the most common reasons are going to be non-payment of rent or a lease violation. Sometimes what's called nuisance, for example, if they're damaging the property in some way or posing a risk to people or property. And then the no fault reasons, things like the owner move in or the landlord says that they're taking the unit off the rental market entirely. And one important thing to note in Santa Monica is that there should always be, or not always, but very often, for example, in a lease violation case, you're required to give a warning notice before the actual eviction notice. Generally speaking, though, as soon as someone gets a threat or a warning notice, and certainly an eviction notice, again, getting legal representation as soon as possible is important. And so I'm going to go quickly through this because Hannah also mentioned some of these things, but just to be aware that if a unit's not rent controlled, there could be eviction protections from these other sources. So the Tenant Protection Act, that's that statewide law that was mentioned. And for many properties that are older than 15 years old, and that's kind of on a rolling basis, they may have rent increases limited annually to 5% plus inflation with a maximum of 10%, and also have a not quite as protective, but just cause for eviction protections as well. But generally speaking, single family homes are not covered under that law either. And then just a few other things here. Sometimes there may be sort of minimal protections for people in special situations. Tenants that have, a Section 8 voucher, a veterans voucher, an emergency voucher. Sometimes there are, rules attached to the particular unit of the property for different kind of affordable housing programs. And then, even for the situations where it seems like nothing else applies, there can be eviction defenses, where there's a substantial habitability, which just means, bad conditions on the property. Although sometimes then the tenant will have to still be able to pay a reduced rent amount in order to defend the case and be able to stay in their unit. Then there's retaliation, discrimination, and reasonable accommodation. If a tenant says, even all the way through the point of an eviction trial, that, they actually needed more time to pay because of a disability, that could be a defense. So, I think it's just generally important to be aware that it can be more complicated than it seems, and there may be defenses that, a layperson would be unaware of, which kind of comes back to just that idea of how important it is for a tenant to have representation. And then lastly, just something we're always trying to remind landlord and tenants is that it doesn't matter what the situation is. You can never lock someone out or change the locks or shut off their utilities. And in fact, landlords could face a lot of legal liability if they try to get someone out through those extra legal means. So that is always unlawful, and that's always bad. So the special school year protection, I won't go super deep into the details here, but I just think it's important to note if there's a student, but also a teacher, and it also covers, I believe, staff members who work in a school. So that could be like an aide or a cafeteria worker or something like that. When a family with someone who is a student or an educator or one of those staff people gets an eviction notice that lands during the school year, they might have a defense to eviction. But this is really a defense to certain kinds of eviction, those no fault evictions. So like when the owner is trying to move in, or under Santa Monica's law, you can also have an owner move in for children or parents, for example, family members of the owner. Or if they're trying to demolish the unit or remove it from use, this can buy families more time, so they're not have their whole lives disrupted in the middle of the school year. The tenant harassment ordinance. This is something that the consumer division in the city attorney's office, it's a big focus of ours. And basically what it does is it bars certain kinds of bad faith misconduct by landlords. And bad faith, that means the landlord is intending to kind of annoy or harass or harm tenants. And so there are a lot of different things that fall under the tenant harassment ordinance, including bad faith failure to do basic repairs or provide services that are required by law. But I want to highlight a couple here that relate to evictions or forcing tenants out. So it's illegal to use fraud, intimidation, or coercion to get a tenant to move out. And they'll actually provide specific examples, which could include excessive rent increases. If it's clear that it's rent controlled or that state law applies, and the landlord knows that it might scare the tenant and make them leave and gives them a $1,000 rent increase, that could be a form of tenant harassment. Baseless threats to evict, and then even baseless eviction notices and eviction lawsuits. Although it's important to note there that the law makes clear that a landlord can't be liable for tenant harassment for filing and actually, taking an eviction case to court, unless the tenant defends the case and is successful in court against the landlord in the case. And tenants can submit complaints to the city for tenant harassment. So the kind of last category that I want to mention is tenant relocation, and I'm seeing we're at 9:50, so I think I'll kind of power through and leave some time for questions. But basically, kind of two things to note: there are when a unit has really bad conditions and a tenant shouldn't be living there, unless it was clearly the tenant's fault and the tenant caused it, then they should be able to get temporary tenant relocation. So the landlord has to pay them basically enough to live in a hotel, and it's a pretty substantial amount, or else provide comparable housing for the duration of the time it takes to make the unit safe to live in again. And then permanent relocation, for many of those no fault evictions, like where the owner wants to move in, they have to provide a very substantial amount to help the tenant find another place to live. And that could be 20,000 or more, just to give a general sense. And then here again, just the resources to reach out to the city, including if you think tenant harassment has happened. The place to start is through the 311 system with that information that's on the screen there. And then, the people who respond to those can facilitate filing a tenant harassment complaint if it seems like that is going to be the best way to get the assistance that's needed. And then I have rent control and the contact information for LAFLA. And then with that, I guess I'll leave the rest of the time for questions.
All right. So if you want to raise your hand or just, talk, you don't have to raise your hand if you don't want to, just say something or put it in the chat. We do have some, some questions, and, Zach put some everybody has been putting some incredible resources. Elissa has put in their zero loan program, and there's all kinds of information for, landlord protections and, really good stuff. So is there, any questions? Shout them out. Raise your hand. Okay, Jonathan, it looks like you probably
Oh, we
didn't
got
have
through
it
all of
quick.
them.
So any of these things that are unclear? Anybody? Nancy, do you have anything to add since you are also an attorney at Betzedek?
No, not really. I think Hannah really covered it. I don't work on the landlord tenant section.
Okay,
But
I'm sorry. I should have
saw
not
somebody
called on
raised
you
their
like
hand.
that.
Oh.
Put you on the
I
spot.
see Rosalind has her hand up.
Yes, Rosie, what's your
I
question?
can't mute myself. I put it in the chat. Are there special protections for age? I had understood that if you're over 65, there's some special protections for you.
Good question.
Go ahead.
Well, I was just going to say that, you know, there are certain protections that it depends what city you're in, but there are certain protections for, like, for instance, if a landlord is trying to do an owner move-in eviction and the tenant is over 65, there are certain protections that would apply depending on where you live. And in some cases, the person moving in would also have to be over 65. In some cases, they would not even be able to do the eviction at all. So it's a good question. And it's definitely, something to explore if a tenant is facing eviction. And in addition, I guess I would also say, like, sometimes with age might come disability and reasonable accommodations. So that's just another avenue to explore to protect tenants.
Yeah, that's a good reminder. I believe Santa Monica does have that provision, but if the landlord or family member is also above that age, then they can still do the owner move in. And there are also some, I believe, enhancements for tenant relocation, for example, for seniors or disabled folks. So.
Anybody else? Any questions? There's some good stuff in the chat. I will copy the chat. I've downloaded the flyers that are in there, and you've got all of the contact information. Jonathan, did you put your contact information in the chat?
I did way back when you said that.
Okay.
So it should be in there if you scroll up a ways.
Okay, and here is one question. Do rental protections cover HUD-VASH vouchers and other tenants who have low-income vouchers such as Section 8, since part of their rent is paid by an outside party? Very good question.
Yeah, it is.
So voucher holders are it would depend on the circumstance. I mean, there may be situations in which different rules would apply, but generally speaking, if anything, there would be greater protections. And certainly I think that's true for HUD-VASH.
Okay. Okay, any other last minute information for people? This has been very good. It's been recorded. I can send out the link to the recording and the chat and the 2 documents that were in the chat.
That does remind me, I think it's always worth just saying briefly, we have in Santa Monica now statewide strong non-discrimination protections against voucher holders, meaning, a landlord should never be turning someone down or treating someone differently because part of their rent is going to be paid by a voucher. And we do enforce that at the city. So we definitely want to hear about anything like that.
I will say, it would be very scary to be a landlord right now.
That's right. That's right.
So many homeless right now, and it makes me sad because you're less apt to take a chance putting somebody in if they can be this vindictive or hard to get rid of or expensive.
Yep, there are those things to consider. And that's one of the reasons why, our rental situation is pretty tough right now. There is another question. Can you send me a copy of the PowerPoints so that I can send those out also?
Yes, I can send a copy.
Okay, and
Yes.
Jonathan, can you also?
Yes.
All right, wonderful. Any last minute thoughts? Hannah, you're up on the screen. Anything you want to say?
Well, thanks for speaking today. Thanks for listening to us. And I learned a lot. I learned about the 0% interest loans, and I shared that with my team. So that's really great to know. Please don't hesitate to reach out to us and refer your clients to Safe House Delay or to Betsedic directly.
Awesome, awesome. Any final words, Jonathan?
No, basically the same. Please feel free to reach out. It's good to see all the different faces and all the organizations that are working so hard as part of this group. So
Thank you.
All right, you guys, thank you so much.